I'm going to talk about litigation financing companies and the relationships that are formed with personal injury clients. First, let me dispel a notion that a lot of people are unclear about. The belief is it's a loan. When litigation finance companies provide monies to personal injury clients, it is not a loan. It is considered an investment. And why is that important? Because loans are governed by a set of laws called usury. Usury laws make it illegal to charge an interest rate that is above a certain limit. So anything that is framed as a loan, meaning you can borrow money, but it must be paid back with interest, that's a loan. Anything that is given, provided monies, but let me just outline that when the loan isn't paid, then the loan provider can go after the borrower for the loan and the interest. That is called recourse. The loan provider can have full recourse against the borrower. Recourse means the ability to pursue the money that you loaned and the interest related to it. So that's what a loan is. Loan is a recourse relationship that the borrower is responsible for, and if they don't pay it back, lawsuits and judgments can be brought against the borrower. Now, litigation finance companies, they advertise and say you can borrow, and they sometimes use the word borrow, but it's not a borrowing. What they actually do is they make an investment in your lawsuit. And the investment that you make or that they make, and what you are doing is selling a piece of your potential recovery. And why do I use those words carefully? Because what the litigation company agreement is with you is it is non-recourse. That means if for some reason you don't recover anything from the lawsuit, you get to keep the money, and it is not necessary to ever pay it back because it is an investment, and they have the belief, the litigation loan company or litigation finance company has the belief that you will be successful, and they are making an investment in your case through you. So they often define the return on their investment in terms of percentages. That's not a loan. They'll say, we charge 20%. Well, the 20% they are charging is really a return rate on their investment. So their expectation is we will provide $5,000, and we, over a period of time during the first 6 months, we want $6,000 back, which may have a return rate of 40% if it's calculated over a full year. That's how the calculations are. Why is that important? Because by classifying it as an investment, that means they are not subject to the usury laws and can negotiate any return that they want on their investment or that you're willing to provide. Now, my firm always discourages people from entering such arrangements and selling a portion of your claim. However, I fully recognize that it is really important at times to, in fact, engage one of these companies. And it's important to really think through, is it worth selling a portion for the monies now, because they do have to be paid back, because the law firm is served with a document called a lien. And I did a whole video explaining various liens and include litigation loans or litigation investments as a lien. And I encourage you to watch that video. But the bottom line is that the law firm, once served with that contract, and most of the litigation finance companies require the law firm to sign before they will even disperse the monies in the investment. Once the law firm is on notice of that, the law firm is required and must pay those monies back upon receipt from the insurance company. So if your personal situation is such that you need those monies for everyday needs, whatever they may be, then while we discourage it, I fully understand and we support you getting them. If you're taking an advance on your potential settlement for something that is, and I'll define it as frivolous, something that is not needed right now and can wait, then I strongly discourage everybody from accepting those monies. The litigation finance companies play an important role because lawyers are not permitted to allow clients to borrow money. It's called champerty. And it is illegal, and lawyers would lose their license if they provided monies to their clients. So the only alternative, unless there's family or friends, is a litigation investment company or funding company, and they do provide an important service. I just encourage you to only take the minimum amount possible because the return on their investment is often quite high. So please be careful. I hope you found this information informative, and if you have any questions or comments or would like other information in other videos, please just leave a message below. Thank you.